and a lot of people don't like banks. So maybe they'll like the outcome of this decision with the self-represented plaintiff getting a $850,000 judgment.
Hello, everyone. Welcome to the next episode of Beneath the Law. My name's Gavin here with Stephen Teal. As always, Stephen, how are you doing?
I'm doing great there, Gavin. How was your day going?
My day is just one hectic fireball after the next. I gotta tell you, it's crazy these days.
There's a lot of issues all over the place. They'll make for great podcasts in the future. Let me tell you.
There's never going to be a shortage of topics. You know, it's one of the things people. I remember asking me why'd you get into the world of civil litigation, and my response was, you know, the one constant of human nature is that they'll always fight with each other. Other things may go up and down, but the acrimony and agitation and conflict will continue. And we are.
And it's getting worse and worse every day.
Yeah, and I'm reminded of that. I'm reminded of that cartoon where you've got the two farmers fighting over the cow and the lawyers busily milking it in the middle. In this case that we're going to talk about today, though, we only had one milker. The other milker was not. He was a self-milker. He was a self-represented litigant. And an interesting turn of events that the self-represented litigant came out on top.
Yeah, sure did, Gavin. What we're talking about is a defamation case involving a former employee against his bank employer, and a lot of people don't like banks. So maybe they'll like the outcome of this decision with the self-represented plaintiff getting a $850,000 judgment against his former employer for defamation that basically caused him a loss of reputation and loss of employment opportunities because what his former employer did.
Yeah, interesting, because, you know, there's a lot of cases. I recall one that came out a few years ago that was supposedly the largest defamation judgment ever granted in Canada. I can't remember the number, several in the multi-millions of dollars, of course, but it was against what certainly appeared to be completely an individual with no means whatsoever, who was a bit of a crackpot, who sat writing, you know, nasty things about people from his basement, or maybe his mother's basement. I'm not sure, but didn't sound like he would be paying that judgment anytime soon. In this case, we've got a very substantial damage award against a party, in this case, the Bank of Nova Scotia, who certainly has the means to pay it. So yeah, this has got teeth.
No, and for sure. And just to let our listeners know, in Canada, defamation cases don't lead to the same kinds of awards that you generally see coming out of the United States. We don't have $100,000 or, you know, super mega $1 million awards that are given by our Canadian courts. So this $850,000 judgment, which is pretty high in terms of the law of defamation. I think the highest award ever was like $1.6 million given or awarded to a lawyer who was defamed on the courthouse steps by another lawyer. You know, so this award is pretty significant. So, you know, just quickly, Gavin, I'm going to get into the case here of the former employee who worked at the bank for 12 years. In their mortgage development department. He was a mortgage development manager in Toronto. Was one of the top producers at the bank in that sector. The bank was conducting a unrelated investigation into potentially fraudulent mortgages, and so they called this former employee, call him Mr. C, in for a interview with respect to some of the mortgages that were processed through him. And basically what they suggested was that those applications contained fraudulent employment information and income documentation, which Mr. C didn't know about. He was just processing these mortgages based on the information that he was being provided through referrals through either real estate agents or mortgage brokers, licensed mortgage brokers. And eventually they suspend him without pay, except that the guy was paid by 100% commissions. So if he wasn't working, he wasn't getting paid. He didn't know how long the investigation would take, so he resigned from his position at the bank, began to look for employment elsewhere at other banks, and then his employer bank decided to create what was called a SIFT alert, and we'll get into that a little bit more later. But essentially, it is a system that is used by banks to flag the fraudulent activities of potentially a bank employee, and they basically said that he uttered forged documents. And therefore, when that was seen by the other banks, Mr. C did not get any job offers by the other banks, and he sued for defamation because he did, in his view, he didn't utter any forged documents. He was just a victim and a potential dupe of somebody else who was doing that.
Right. So we've got it in the context. I think it matters here. You've got, and I think that the facts were that he couldn't accept referrals from strict mortgage brokers. I don't know how much that matters. It was just as a policy of the bank, but he could accept referrals from real estate agents who were also mortgage brokers. It just strikes me that, of course, I'm not suggesting that anyone was knowing this, but it's certainly in the interest of everyone involved in this chain, in this commercial enterprise. Everybody seems to be compensated on successful closings of transactions. So everybody's motivated to close the deal. And of course, in order to close the deal, you need money. And in order to get the money, you've got to put forward applications that are going to pass various tests, I suppose, that the bank would put forward, which would include your ability to pay back the loan, and which would include that you'd have a good job, that you were getting paid a certain amount of money, and that you could afford to pay those mortgages. So these applications come in through this gentleman. I mean, the bank is in a competitive business too. They're competing with other lenders to lend out money. That's how they make money for their shareholders, is they take in money and they pay you interest at X%, and then they lend it out to somebody else and they take a loan back at X plus 2%. And that spread is how banks make money. And here, everyone was motivated to make the loans. Of course, what happens then is when the income and employment is fabricated, nobody goes into these transactions thinking that the real estate market's going to collapse or that they're not going to be able to carry it, but they can't carry it. And then mortgages go into default. It turns out that, borrower did not make $100,000 a year. That borrower was not employed by XYZ Corp. Borrower is really unemployed and has nothing and could never have made this mortgage payment, and the bank would never have made the loan had they known that. So that's the fraud that comes to light. And then they go back and they start to say, how did this borrower come into the bank? And they found that it came in through this particular agent, and they imputed, or they alleged that he must have been in on this fraud in these forgeries, or this exaggeration, if you will, of the borrower's means and ability to pay back the bank.
Yeah, and from a factual standpoint, the bank actually did not, in its investigation or its interview of Mr. C, actually advise him that they were investigating a fraud behind these mortgages. Rather, they were essentially, with respect to him, investigating him under a notice that there were certain irregularities that had been committed with respect to the way, I guess, that he processed the transactions, and that it came through the referral through a licensed mortgage broker that, under the bank's policy, he was not supposed to necessarily deal with, because licensed mortgage brokers were supposed to be referred through other folks at the bank to process mortgages. So they never really actually accused him of being involved in fraudulent conduct.
Well, they ultimately did, because that's really where
they ultimately
the defamation occurs.
Right.
Because they did two things. First of all, they forced this gentleman's hand because they suspended him with pay, they said. But of course, he's 100% on commission. So if you're suspended, you can't do any deals. Guess what? Your with pay is no pay at all. So
completely
he is
meaningless.
basically starved out of a job. And then when he goes to look for another job with another bank, and because that's his business, he's in the business of placing mortgages with lenders. When he goes to look for another job with other banks, they blackball him, for lack of a better word, on this interbank system, where they say that he was knowingly involved in uttering fraudulent documents. In other words, not only that he was asleep at the switch and taking these documents into the bank system, but he was involved and knowing that they were fraudulent and pushed them through the bank anyways. That's obviously a very different type of conduct than just being kind of not potentially as aware as one should be, and questioning potentially as deeply as one should in terms of applications to the bank, which I don't know if even that was even his job. I mean, his job seems to be that he was the referral source, not the underwriting person who decided whether or not to make the loan ultimately or not. That I would assume, fall to somebody who wasn't compensated on the loan going through.
Yeah, it would certainly be one thing, Gavin, if there was evidence that he was involved with a particular mortgage broker or a particular real estate agent to scam the bank out of mortgage proceeds on a knowing basis, but that wasn't the system. Just to put it into context a little bit, the banks have basically a crime prevention and investigation office that's set up through the Canadian Bankers Association. And what that is essentially used for is to notify other financial institutions in that particular industry where employees have committed serious criminal acts, that they don't move from one bank to another. And that's basically to protect, I guess, everybody in the banking system, not only the banks themselves, but consumers from potential bad actors. But those procedures have guidelines. And the one thing that banks are not supposed to do is circulate somebody's name on this system called the SIFT alert system. And that's SIFT for anybody, SIFT, like I think it's the salt, but anyway. That's SIFT. Oh, okay. Similar. But anyway.
They're sifting the wheat from the chaff. They're
right.
Sifting the good employees from the bad employees on the SIFT alert system.
Right. But you're not supposed to add anybody's name onto that system where they're just simply, as Gavin said, asleep at the switch or incompetent in terms of doing their job. And interestingly enough here, notwithstanding what the bank investigator had put on this alert system with respect to Mr. C uttering knowingly false documents, they never involved the police. The bank never involved the police.
Right. So let's get down to what we're really talking about here. So that the employee, after he's blackballed on this system and basically accused of being a fraudster, sues. He does so himself. He doesn't have a lawyer. The bank responds. He sues in defamation. So let's talk about basically the three elements for a successful defamation case. Number one, there has to be a publication of a statement referring to the plaintiff. You've just pointed that out. They named the guy on the SIFT system, so they get through that gate. The publication must be to a third party. As you pointed out, this publication goes out to all the banks. They share information on who they call the bad guys so that the other banks are forewarned about dealing with these people and not hiring them. And then 3, the publication must tend to lower the reputation of the person that they're talking about in the estimation of a reasonable person. So he easily gets through, I think, all 3 gates. I think the bank ultimately conceded that he was through all those gates. That means he's been defamed. He now turns the tables on the bank, and it's up to the bank to prove by way of a defense that even though they defamed him, that defamation was not something that they should pay any money for, that they had a defense to say why that defamation was appropriate in the circumstances. Number 1 is that it's not defamation at all. It's really, I think that the defense of justification is really not a defense to defamation, because one of the key elements of defaming anybody is that it can't be true. If I can't defame you by telling the truth about you, so the notion that the statement is true automatically is a complete defense to a claim for defamation. But I think realistically, from any defendant's perspective, you have to be super cautious with respect to the defense of justification, because you're effectively doubling down in the defense on the original defamatory statement, and you have the huge risk of aggravating further the sting of the original libel. And that's ultimately, I think, what drove quite a bit. Reading into the judge's mind a bit, but I think the judge was like, they still didn't back off of it, even though they were forced, I think, by the record to admit that they had no evidence anyways, that he was actually involved in the fraud, or that he was actually aware of the fraud such that he was a participant in it.
Yeah, so that was one of the defenses that the bank raised. And so the justification defense, as you say, basically undermines the defamation because the defendant says, well, what I said about you is true or substantially true, that I was justified in making that comment. Except that in this case, as in all cases where a defendant has to rely upon a positive defense in defamation, they bear the burden of proof. And the bank's case really crumbles on that position because they actually didn't call the investigator who interviewed Mr. C as a witness. They gave the excuse that that person was no longer at the bank and was living out of the country. Well, if they knew that that witness was living out of the country, they must have been able to surely have called that person as a witness in this day and age of, electronics and being able to call somebody by Zoom into the courtroom to give evidence. But they didn't. They gave evidence of some other people at the bank, which the court was very critical of because that was hearsay evidence, and in some cases double hearsay, because somebody was relating a conclusion that somebody else had given.
Right, and in fact, I think that the case, the trial judge came to the conclusion that after carefully reviewing the investigator's notes, that she had, in fact, never concluded that the plaintiff knowingly submitted fraudulent documents. That there was no suggestion, or a careful review of the notes did not indicate that the investigator came to the conclusion that this individual, in fact, was a participant in the fraud, or at least even knew about the fact that it was a fraud. She had never come to that conclusion, at least from her notes.
But that was the same investigator who posted this alert on the system, and then was never called as a witness.
Right. So the bank's decision to proceed with the justification defense, everybody plays Monday morning quarterback reading a decision, and it's very difficult. When you're litigating a case, you make sort of game time decisions, or you make decisions based on how you think the evidence is going to come out, and sometimes it comes out that way, and sometimes it doesn't. But the lesson for me is when you're defending a defamation case, you have to be careful with the defense of justification, because there's a lot of defenses to a defamation action that don't require you to prove that what you said was true. But when you say what I said was true, and you swing and miss at that defense, you really aggravate the original libel because you really underline what your client said about that person and continues to say about that person all the way through a trial to a judge who is going to decide how much you're going to have to pay for defaming that person. So you are effectively increasing your exposure to damages through that defense if not made out.
100% correct. And, the other defense that the bank relied upon in this case, Gavin, for those who practice defamation and for those who don't from an educational perspective, they relied on the defense of qualified privilege. And that defense basically is premised on the notion that the person who speaks the defamatory comment or publishes the defamatory comment has some kind of positive duty to do that, and that the people that they publish that comment to have a right to receive that kind of information. So in the banking industry, we talk about the SIFT alert system. There would be a duty to publish and a right to receive in the bank context this kind of information, except that defense too failed because there never was a duty to publish the alert about Mr. C because he had not ever engaged in a serious criminal act, right? It was more that he had breached or was offside internal regulations and processes with respect to these mortgages. He was never involved in the fraud as an actual perpetrator of the fraud. He was a victim just as the bank was. So that defense crumbled, which also, then raised the entire issue of whether the bank had acted maliciously. That was another argument that the plaintiff made, that the bank acted with malice. And the malice really was, with respect to the bank, never taking a closer look at the alert that had been circulated over the course of the litigation when they were sued for having made the defamatory comment to begin with.
Yeah, I mean, I think the malice element of this, I think what the judge found was, and remember where we're sitting, we're at a trial, there's been a claim, the banks theoretically had a hard second look at the publication. They defended on the basis of justification, saying after they've had this hard second look, we still stand by that comment, it was true. They maintain that position all the way through trial. A judge disagrees with them that it's true. So in other words, the bank may have believed it was true, but they've got to come to the conclusion at that point that the judge disagrees with them, that it's not true. The judge has found it's defamatory. And it comes back to my point. I don't know how the bank can admit that the statement is defamatory and still say that it's justified by the truth. If I come back to the mixed question of, I don't think you make out defamation with a true comment, and I don't think you get it. It is really a defense. I think it's a natural element of the tort that the statement has to be necessarily untrue because you can't be defamed, as I say, by the truth. But be that as it may, they carried that all the way through to the end of the trial and lost. And at that point, the court found that the bank was reckless in refusing to examine what they'd said about this individual versus what they could actually, or what they actually were alleging about this individual. What they could actually prove against this individual was that at most he had just been incompetent in terms of reviewing the requirements for the loans, not necessarily participating in the defrauding of the bank through the making of false applications.
Yeah, and so that all mixes into the ultimate damages award that was granted, because not only does the court then award the general damages, which, $75,000 general damages was what Mr. C got, but he also gets $100,000 in aggravated damages because of that specific tactic or a way that the bank defended the case. So that, he's on this alert system for 7 years, which my understanding is that's how long these records exist, and isn't able to get a job at the bank because every time somebody was to go in there to check who he was, it would have popped up. So, he's basically being harmed every day for a period of 7 years.
Right, and blackballed from his industry.
Right.
And that's one of the real dangers with this, the power that exists in terms of these types of inner group ratings or recommendation sites. It raises real issues. I mean, in terms of this was an active blackballing of an individual, but it's, for me, I mean, I can think of instances where there could be claims, for example, where somebody's seeking a reference from an employer gives a very bad, false review about a potential or a former employee, and that person doesn't get a job. I mean, is that defamatory? Maybe, could be. This is a proactive sort of reference point where they go out and they publish a review, if you will, or a statement about this individual, such that they are, as I said, blackballed in that industry, and they have really no chance of getting further employment. The court recognizes they gave him $475,000 for loss of income for the fact that he couldn't get another job as a result of the publication.
Yeah, or while he actually, I guess, got another job, but outside of the banking industry, he got a job as I think, mortgage broker eventually, but, essentially has to start more from square one, so to speak. And that impacted his damage. What really impacted his damages, though, was his resignation from the bank. Had he stuck to his guns, so to speak, and remained on suspension, he may have been entitled to a much higher damages award.
For what?
But he had to make a choice, right?
Well, I mean, he probably had a pretty good argument for constructive dismissal in any event. I mean, getting suspended with pay that means I don't get a penny sounds to me like constructive dismissal, but I mean, who knows? I mean, it's also difficult on a wrongful dismissal case. In this particular instance, I mean, was there cause for dismissal? There might have been cause for dismissal, in the sense that he was incompetent and breached the guidelines of the bank. I don't know what his employment history was or anything like that. That arguably could be cause. Or
could have been cause.
But
right.
it's the lying about him or the what the court found to be the untruth in the publication that led to the defamation claim, which is a different cause of action, of course, than wrongful dismissal.
Yeah, and that was, look, the special damages were quite substantial. $475,000 is not an insignificant amount, but also for the bank, they got hit with a $200,000 punitive damages award. And again, that's not insignificant. In general, punitive damages awards in Canada are much lower than that. You don't tend to get into six figures, but because it was the bank, and, I say big bag bank at the start, in jest, of course. I mean, it's more perception that many people don't like banks because they make a lot of profit, but, this is a very prominent business, and that's a factor that gets taken into consideration in a punitive damages award, is the size of the defamer. And so they got hit for another $200,000 there, bringing up that total to $850,000, as we said at the outset, which is a very significant damages award in a defamation case in the Canadian context.
Right. Very significant. Very significant indeed. I mean, there's a lot of findings in this a fact here that I understand the matter is being appealed. And we're wait to hear what the Court of Appeal says. But of course, there are, as I say, a lot of findings of fact in this case that, you don't, generally speaking, findings of fact are not going to be disturbed on appeal.
No, and I don't want to gaze too much into the crystal ball here. I'm not sure that the justification defense will hold water even on appeal. Qualified privilege, I don't know. I'd be on the fence on that one. I kind of lean more in favor of Mr. C there as well. It'll be interesting to see what comes out at the appeal, but damages awards are very difficult to appeal.
Very, very difficult. It's especially with these types of numbers where they really are in the discretion of the trial judge. I mean, one thing that the trial judge didn't
And they're not outrageous overall.
No, they're not. The court the court did criticize the plaintiff somewhat in the fact that there was not any expert evidence led to calculate loss of income, and I suppose the plaintiff could have increased the amount by having expert evidence on what his actual loss of income claim was, given the fact that he's a commission salesperson, right? He's a commission person. That's how he earns an income. Not so easy just to calculate it in terms of a salaried employee where you just multiply it by the number of months and here you go. I mean, this is an individual who would need to be able to prove to the court on balanced probabilities that but for the wrongful conduct of the defendant, they would have earned X amount in income. And as a result of the wrongful conduct of the defendant, they were unable to do so. And that he needed to lead expert evidence on. He didn't do that. So the court did discount the amount significantly as a result. I think if he had led expert evidence on that point, we could be looking at a damage claim well over $1 million.
But right. And so that's, I think, Gavin, when I looked at this case, when it came out, that's really what this case turns on, is a lack of evidence on both sides, right? The bank not putting forth the first-hand evidence as to why it issued this alert, didn't put its investigator forward, which basically harmed the defenses that they were relying upon. And then on the opposite side, the plaintiff may have been entitled to a higher damages award on the special damages side by having that expert evidence to lead the proper actuarial kind of evidence that one might normally do in a employment kind of case in terms of loss of income.
Exactly. So, well, I think we're out of time, but very interesting case, and goes to show you that sometimes the self-represented litigants come out on top, and they certainly did in this case. We'll be following the appeal to see what the Court of Appeal has to say about this decision, and if indeed he goes forward with the appeal, or who knows what happens between then and now. And if it doesn't, then I guess we'll never know what happens. But anyway, Stephen, thanks very much. Very interesting conversation once again about a topical case that certainly brings to light the great harm that can be done by posting online, particularly where you have the credibility of a major bank. And if you're going to post something online, you better expect people are going to believe it, and you better be prepared to live with the consequences. So post very, very carefully. So, Stephen, that brings us to the conclusion of this episode. And once again, thank you to our producer, Doug Downs, does a fantastic job as always. Thank you most, though, out to our listeners, to all of you. Really appreciate you taking the time to listen to this podcast, and hopefully you take something away from it that's of value. We certainly enjoy doing it and really love to hear your feedback, comments, criticisms. Ratings are always enjoyable. So far, so good in the ratings department. And if you really like this podcast, pass it along to your friends. Maybe you could have, particularly if you get people who don't agree with some of the views that we state on here. One of the things about that we always talk about is that, it would be we actually would have no livelihood if everybody agreed with one another, because it takes two sides of an argument to have an argument, and you can't dance by yourself, and you can't try cases by yourself. So every case has 2 points of view, one of them successful, one of them not. But if you didn't have 2 points of view, it'd be a pretty boring litigation world, that's for sure. So thanks very much to everyone, and always remember, if no one is above the law, then everyone is beneath it.